All right, and we are back on the record in cause number 2022-0D03647, State of Texas versus Manuel Castro. The court allowed you, Mr. Castro, to speak to your attorney a little bit while we were off the record, and so you could consult with him. Are you prepared to go forward with your plea, or did you want to stop the plea?
I want to stop the plea. I want to plead guilty, Your Honor.
Okay, so let me go back because that's a couple of different things. So I'm going to go back more or less where we left off. And when I'm asking you to the charge, second-degree felony, aggravated assault with a deadly weapon. You understand what that charge is? You talked to your attorney about it?
Yes, Your Honor.
Okay, now you understand that when I'm asking you for a plea, I'm asking you whether you did it or not. Do you understand that?
Yes, Your Honor.
Okay, so to the charge of aggravated assault with a deadly weapon, what is your plea? Guilty, meaning you did it, or not guilty, meaning you did not do it?
Guilty.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
And you don't have any misunderstandings about what your plea means, correct?
No, Your Honor.
Okay. Then I will find that you are making your plea freely and voluntarily. Ms. Raga, would you summarize the evidence, please?
Yes, Your Honor. State of Texas versus Manuel Castro Jr. and cause number ending in 3647. If the state of Texas were to proceed a trial, the state would have proven beyond a reasonable doubt that on or about the 29th day of August 2022 in El Paso County in the state of Texas, Manuel Castro did then and there intentionally or knowingly threaten Manuel Castro Sr. with imminent bodily injury and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, an axe, in a manner of its intended use that was capable of causing death or serious bodily injury. The plea agreement, Your Honor, is 5 years deferred, $1,000 fine, probate $1,000, 200 hours of community service, UABA, curfew, no contact with CW, which is Manuel Castro Sr., anger management, BHRTC, all of their standard terms and conditions, with the dismissal of 2022-0D03536. At this time, the state moves to enter into evidence. It's Exhibit 1 and 2 if there's no objections.
No objection, Your Honor.
States 1 and 2 are admitted. Judge Trochet, is that your understanding of the plea agreement?
It is, Your Honor.
And Mr. Castro, is that your understanding as well, that offer?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Castro, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
Was signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Mr. Castro, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, Your Honor.
Judge, have you explained to your client both the benefits and detriments of deferred adjudication?
I have, Your Honor.
Mr. Castro, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for this offense? Do you understand that?
Yes, Your Honor.
And are you asking the court to grant you deferred adjudication? Mr. Castro, are you asking the court to grant you deferred adjudication?
Yes, Your Honor.
I will find there is sufficient evidence to substantiate a finding of guilt in this case. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 5 years. There will be a $1,000 fine. The entirety of that fine is probated. 200 hours of community service, urine and breath analysis, curfew, no contact with the complainant, court costs, anger management. There is a dismissal to be signed in cause number 2022-0D03536. I saw a notation regarding BHRTC. Is this gentleman going to BHRTC?
Yes, Your Honor.
I'm sorry. I received a email from the probation department wanting to know, and we said that he should be evaluated to see what his needs would be. And so as I understand it, he may end up there, but he's going to be evaluated first, as I understand it.
And so is there nothing else that he's being detained on?
No, Your Honor.
No? Okay, so your client knows, Mr. Castro, that they are looking, I mean, I'm not sure how we're doing a BHRTC recommendation if we're gonna let him out. Carla, has anybody done any type of screening at this point?
No, Your Honor, my, just for clarification, my question was just if there was any indication of any substance abuse issues,
Mhm.
which, Judge Troche did inform me of, there was some kind of substance abuse plus the dismissal of the possession charge. So in other words, we're not gonna screen him. I'm just going to do direct placement to BHRTC right now for the plea purposes.
Okay. All righty. Well, I mean, part of my concern there obviously is that if he's going to BHRTC, then he needs to remain in custody because he has to be in custody to go to BHRTC. Did you explain that to your client, Judge?
Your Honor, I don't think the BHRTC was part, and Ms. Rago can correct it, was part of the plea in this case. In
It's
other
on the
words,
papers.
right,
We can abandon it, Your Honor.
Let me ask, has he been on, I don't know, has he had any treatment beforehand? Any drug treatment? Carla, do we know that?
I don't actually.
Have you ever gone to any inpatient treatment, Mr. Castro?
No, Your Honor.
Have you received any drug treatment with respect, any drug treatment?
No, Your Honor.
So we're gonna just screen him, do some type of, I don't know, drug, substance abuse, substance use screening and see where that gets us. But I will tell you that if they do screen and make a recommendation of BHRTC, your client has to be in custody. I feel like it's not gonna be that. Because if it was that severe, I think we would have already had some indication of some prior treatment. So we're gonna get him screened for drug and alcohol use. I'm not sure what is there. So no BHRTC at this time. He's gonna be tested, Carla, every, so monthly and then one random test every month. So that's twice a month. So we get that until we get that screen taken care of and we see what, if any, treatment he is recommended to take. Okay. Is there anything further, Ms. Rago or Judge Troche?
Nothing from the state, Your Honor.
Your Honor, the only thing is that the complaining witness in this case is his father, and I understand that he's not to be, go around and talk to his father, but he would like to speak with him on the phone as long as it's not, and I think the father would be receptive to that, talk to him on the phone, because he did reach out to me at some point and expressed a desire to get him some help and then go from there. So,
Ms. Rago, do you have any indication, was your complainant asking for no contact or no offensive contact? Do you know?
Let me check, Your Honor. The agreement was no contact. We can do no offensive though. That's okay.
Did you speak to your complainant before this plea?
I had requested the plea papers I requested it to be done for my victim advocate, but I don't have an indication that he did it.
Okay, so we'll go with no offensive contact.
Okay.
Anything else?
Nothing further from the defense, Your Honor.
Thank you very much. Thank you, Mr. Castro.
Bye-bye.
Who's next?
Alex, may we have Gutierrez?
Yes, sir. You're right.
In cause number 2022-0D04727, State of Texas versus Autumn Alyssa Gutierrez. Announcement of council, please.
Samantha Raug on behalf of the state trev, Your Honor.
Roger Montoya on behalf of Ms. Gutierrez, and we're ready, Judge.
And Ms. Gutierrez is appearing remotely from the jail annex. We are scheduled for a bond hearing. Mr. Montoya, you may proceed, but would you please tell me what is her bond?
According to the jail records online, Judge, it's $200,000. There's some kind of split. I don't have a copy of the order to be able to tell you what the split is.
Okay, I'll look it up. Go ahead, you may proceed.
Thank you, Judge.
Mhm.
Well, first of all, that amount right on its face, $200,000, with all due respect to the magistrate who said it, does seem to be designed to keep her in jail rather than to secure her appearance in court, Your Honor. I do understand that the charges of aggravated robbery, burglary of the habitation with intent to commit a felony, and injury to a child or elderly or disabled person have great shock value. I mean, on their face, they are very serious offenses as alleged. And I think that perhaps the amount of the bond reflects that. And I think we just got, I think it looks like 150 surety and 50,000 PR.
Got it. Thank you.
And so, Your Honor, this lady obviously is indigent, as indicated by the fact that I am court appointed. She indicates no employment on her application for court appointed counsel, no income. She's a student, Your Honor. She was studying to receive her GED at the Isleta Community Learning Center. And she would like to continue doing that. Her grandmother, Mary Ortega, has been in touch with me. And so she has supported family. You know, my client's only 18, Judge. She's a student. I know the court, the state's going to address you regarding her record, but I don't think she has much of one. And regarding one factor that the court can take into consideration, which is the strength of the case, for the most part, as I read the facts in the police report, my client's participation is minimal, if any. Mostly she's just present when the two other, her co-defendants, there are a total of 3 people who are allegedly involved in this offense. And her co-defendants are the ones who are alleged to have committed the lion's share of the violence here, if not all of it. The complaining witness was allegedly wielding a bat, and that's when allegedly one of the other co-defendants drew a firearm. My client is not alleged to have held a firearm at any time during this alleged offense, Judge. And like I said, so on their face, the charges have a lot of shock value, but as the incident unfolded, you know, one person was allegedly injured. The rest of it was pretty much by way of threats. And the weapon, funny enough, Judge, was recovered inside a vehicle. It wasn't even recovered in the habitation. Okay, so I don't know how that allegedly, you know, how that unfolded, but at any rate, the case against my client, I would say she's the least culpable of the parties involved, Judge. She was actually trying to get away from a domestic violence situation. My client is a victim of domestic violence, and I would like the court to take that into account in considering this bond. And so, Judge, you know, I really feel that $200,000, even if, you know, it's 150,000 of it that's cash or corporate surety, it is on its face excessive, Judge. Like I said, it appears designed to keep her in jail rather than to keep the alleged victims or the society in general safe. And if they need to be kept safe from anyone, it would be her co-defendants. My client is fully prepared to follow any and all conditions that the court could set. I do believe there are combinations of conditions the court would set that would ensure the safety of the community, of my client, of law enforcement, and the alleged victims in the case, and that would assure my client's appearance in court. when I spoke with her, she appeared to be a very conscientious person. I do believe that she is not a flight risk. Like I said, her family lives here. She goes to school here. She lives here. She's going to show up, Judge. And I would respectfully request a full PR bond with very strict conditions. She will definitely obey a condition that she is not to have contact with the complaining witness and his, I believe it's the grandmother or his mother. Either way, she has no intention of going back to the boyfriend. She's not going to contact him, even if I think maybe some of her property is still over there at their house. She can forego collecting it until this matter is resolved, or I might be able to help her with that. Whatever way it works out, she's not going to use the property as an excuse to go back to that house. She will remain in her own home and go to school and do whatever it is that she needs to do. She won't bother those people. And I believe that's all I need to say on behalf of my client for now, Judge.
Okay, Ms. Rago, go ahead.
Yes, Your Honor, the state respectfully opposes a full PR bond or reduction, Your Honor. This defendant, the victim is her boyfriend at the time. The state's understanding was that the defendant was living with her boyfriend, which is the younger CW, and the grandma at the time. They left, came back with two individuals, which are the co-defendants. Mr. Montoya is correct, as she didn't specifically point the gun. The report didn't really indicate, I know it went back and forth whether the elderly woman was shot. There was an indication on the 911 call and initially that there were shots fired. We attempted contact with both CWs. Unfortunately, we were met with negative contact, and so our office is going to send out a 5-day letter and continue to try to contact the CW. Based on the association through the law parties, the state's concerned about the safety of the victim through this defendant. In addition, this defendant was seated in the passenger seat, and the handgun was found under the floorboard, partially underneath the passenger seat as well. One co-defendant was in the back seat, in the back behind the car. The other one was in the driver's seat at that point. And so the state is concerned about the safety of the victim, and also where the defendant, if released, where would she reside, because she was at one point living at the victim's home.
All right, I don't know if that, let me see. In terms of the bond, Mr. Montoya, it looks like the clerk is contacting the jail because initially I think it was 75,000 on each count, 25,000 PR, but she hasn't been booked on count 3. So we'll see what information we can get there. Let me look up some of these. Did you have anything else, Mr. Montoya?
Judge, respectfully, if the court is not inclined to grant a full PR bond, which I think the court would be safe in doing so, in the alternative, I would be asking for a corporate surety aspect under $10,000, because anything over 10,000, and I'm sure the court's aware, any bonding company is going to require collateral for the full amount of the bond past $10,000. But if we keep it under 10,000, then the bonding companies will be okay with the family just putting down cash.
Yeah, she doesn't have much of a criminal history, but it's more the nature and circumstances of the allegations here, the concern for the community safety. I mean, these are not, I know they're just allegations, but they're not So the PR bond is definitely not happening. It's not going to happen on an ag robbery, that's for sure, and violence that's involved in this case, or threats of violence. But I definitely don't think I can go where you are, Mr. Montoya, so I don't know that it makes a whole lot of difference. What I will do is reduce the cash surety portion of her bond to 75,000 and leave the remaining PR bond the same, including the conditions. I know that may not, well, it probably is not going to work for your client, but based on what I have here today, that'll be the order of the court. I know things sometimes develop, and if you need to come back and readdress the bond, Mr. Montoya will do that. Her arraignment is next week, and then we have her set for trial in June. So as you all go through and work the case, you need to come back on the bond, let me know, and we'll set it.
Thank you, Judge.
Thank you, Mr. Montoya. Thank you, ma'am. Who's next?
And next, may we have Perez?
Yes, sir. Give us a couple of seconds, sir.
Yes, sir.
Ready?
In cause number 2022-0D04896, State of Texas versus Vincent Allen Perez. Announcement of council, please.
Samantha Rogg on behalf of the state. Seats ready, Your Honor.
Rick Huffman on behalf of Mr. Perez, we're ready, Your Honor.
And Mr. Perez is appearing from the jail annex remotely as well. We are scheduled for a bond hearing. Mr. Huffman, you may proceed.
Thank you, Judge. Your Honor, Mr. Perez is 47 years old. He is a U.S. citizen, born and raised in El Paso. Basically lived here his whole life, Your Honor. His family lives here, his mother, his siblings. So he has basically all of his ties are in El Paso. He's been in custody since November 6th, so almost 2 months. The bond on this case is $20,000, and he does have 2 related misdemeanors. And Judge, we're asking the court to consider reducing the bond out of this case. Currently, Judge, Mr. Perez is unemployed. He is trying to get social security, and he actually has a hearing with the Social Security office January 10th. And he's being represented by Reyes and Reyes for that. He has a number of confirmed mental health diagnosis, Judge. Basically bipolar, schizoaffective, that type. Since he's been in custody, Your Honor, he's been taking Abilify. I've spoken to him a number of times on the phone, and I've seen him at the jail, and he seems to be doing very well on Abilify. And Your Honor, if the court considers reducing the bond, and if Mr. Perez is released, we would ask the court to basically order services through Takumi. Mr. Perez is familiar with Takumi. Unfortunately, right now his case is closed with EHN, but it's my understanding that if the court refers him to Takumi, he will be able to get an assessment very quickly, and he will be able to continue his medication. I believe if released, Mr. Perez knows that if he requests the medication be given to him, the jail will give him about 10 days worth of medication. But it would be kind of pretty close. I don't know if he would be able to get that medication within the 10 days, but if ordered through Takumi, he's got a shot at getting very close to getting that treatment. Your Honor, as far as the case, Mr. Perez was having a mental health episode. He did walk into a front yard that was gated. He walked in through the gate, and he went into a front yard to pet some dogs. At which time the owner of the house came and didn't like that and locked him in to the front yard. And basically, Mr. Perez wanted to get out, and according to the report, Judge, there was a piece of wood that was flung over the fence and it hit the complaining witness's hand and basically caused a scratch and some swelling. I looked at the pictures, Judge. I didn't see anything that would indicate any scratch or swelling. Judge, I think it's a bit of a stretch to say that the manner of which that he used that piece of wood was capable of causing serious bodily injury. We know it didn't, and I just don't see how him flinging it over a fence is capable of causing serious bodily injury. But obviously, Judge, that I guess that would be a question for the jury. I think the bigger issue is why was he being locked in a front yard? But anyway, Judge, so we're hoping the judge would consider releasing Mr. Perez. He does have a place to live. I've confirmed that. It's a family friend. Her name is Yesenia Cedaños, and I do have an address for her. And I have confirmed that with her that he could stay with her. So, Judge, we're hoping that Mr. Perez has an opportunity to get out and basically do the Social Security hearing and to get treatment. I think he does well on his medication, and we're hoping that he would be given an opportunity to basically be released. And he does promise to go to court. He wants to accept services through Takumi, and he promises to comply with any conditions the court would put on his PR bond if the court releases him.
All right, Ms. Rocco, go ahead.
Your Honor, the state respectfully opposes a PR bond. The CW, he did go to William Beaumont for a sprain in his finger, and they actually had to put it back in the socket. We had contact, that was when he contacted our office on 11/7/2022. And then today we did have contact. The state is concerned about the defendant's criminal history. There was an attempted murder in 1994. He was placed on 10 years deferred and was later the motion to adjudicate. He pledged through to 13 years TDC. That was the first pen trip. In addition, there was an attempted murder of 1995 that was reduced down to misdemeanor. He did 90 days. Possession of controlled substance, PG1, more than 4 grams, but less than 200 grams. That was in 2007. A second degree, he did 30 months, and that was pen trip number 2. There was a misdemeanor assault in 2010. A sale of alcohol beverage without permit in 2012. He did 7 years to do. That was pen trip number 3. Assault on a public servant, that was dismissed in 2011. Assault bodily injury was a felony that was reduced down to misdemeanor in 2020. An AFV of a misdemeanor 2021, that was a conviction, and then 2 VPOs of 2022 with 2 different complainants, Your Honor. And so the state is concerned about non-compliance while on probation in his criminal history, Your Honor.
Okay. Mr. Huffman, do you have anything else?
Just, I haven't had an opportunity to review those medical records, but I would definitely, the pictures do not indicate any injury that I can see, Judge.
Mm-hmm. And no resources towards a bond? Is that what you said?
Your Honor, his mom does have a couple $100 at most, and I have spoken to his mom about that.
Okay, let me look at something. Yeah, I think again, I think it's a situation where we're not going to be where you need to be. So I'm going to go ahead and deny the request to reduce the bond. Thank you very much.
Thank you.
No.
All right.